Madam Chairman, committee members, my name is Dwight David Mitchell, and I'm the Executive Director of Family Preservation Foundation, a nonprofit 501c3 organization founded on the idea of rescuing children from unwarranted forced parental separation, family preservation, and the Family First ideology. Currently, there are over 900 members in our parental association. The topic of my public testimony today is based upon a Russian proverb. It's called Trust but Verify. I want to speak to you about what I feel is a pressing social issue. Now, it's not nuclear arms, it's not immigration, and it's not the coronavirus. As many of you may have already guessed, I'm here to talk about what I perceive are opportunities for efficiency and changes within the child protection and foster care system in Minnesota. While I think we all agree there is a need for child protection services in this country, the way it is currently administered is open for much debate, as can be seen by the recent passage of the Family First Act in Congress and the signing of that bill by the President, which was due to go into force October of 2019. The number one priority of family preservation is to keep children out of the failing foster care system and with their families whenever that is possible. When I last presented testimony before this assembly 3 years ago, I advised the task force that Dakota County chose to ignore those laws that you, the legislature, made even when notified of those laws. Dakota County and state officials fabricated evidence, withheld exculpatory evidence, lied, and went about their illegal activities with a brazen arrogance, totally without fear of reprimand, reprisal, or the consequences of their illegal actions while retaining my children. My case is not isolated. This is still happening all over Minnesota, and we are being contacted daily for assistance. After reviewing the 2018-2019 reports from the Minnesota Department of Health Services, I feel very little has changed in the past years and that Child Protection Services is still acting as it was before. It's business as usual, before any of these new legislation has been enacted. In fact, the number of children removed has increased from what I can gather, and there is still a lack of oversight and accountability at all levels of CPS. Earlier, I mentioned the top of my testimony being trust, but verifies. Well, today I'm going to present to you my verification and my 6 key findings after looking at the annual reports from the Minnesota Child Protection Services and the Minnesota Judiciary. Based upon the Minnesota Department of Health reports and the Data Privacy Act that for the information I requested from the Minnesota Judicial Branch, I was informed of this. While this taking of our children has hit African American families disproportionately, I'm here today for all Minnesota families. So here are my key findings. 1, as reported to the legislature by the Minnesota Department of Health and Human Services, there are over 3,500 cases in the past 5 years where county social workers alleged that child abuse had taken place in the Minnesota court system. Pursuant to Minnesota Statute 260C.176 and the Minnesota Rules of Juvenile Protection Procedure, my question was, during the past 5 years, how many of these 35,000 plus cases were represented by legal counsel before children were removed at the CHIP's 72-hour emergency protective care hearing without the social workers having to provide evidence of child abuse? The answer, 669. As reported by the Minnesota Judicial Branch. Number 3, pursuant to Minnesota Statute 260T503, the social worker must substantiate the allegations of abuse within 60 days or less of child removal. My question was, during the past 5 years, how many of the 35,000 plus cases commenced to trial within the 60 days from the date of the emergency protective care hearing and the child was actually removed from their home as required by law? The answer was a shocking 488 cases as reported by the Minnesota Judicial Branch. 488. As reported by the Minnesota Judiciary, over 16,000 of the 35,000 cases had attorneys at the admit-deny hearing in the past 5 years. Public defenders represented the majority of the cases, and over 50% of the parents went through the entire legal proceedings unrepresented by legal counsel, up to and including the termination of their parental rights, without any legal advice whatsoever. Based upon the public defender's training manual that I received from the Minnesota Judiciary Branch, public defenders are not trained to defend the parents. They are trained to get the parents to admit to the allegations and persuade them to comply with the social workers and to actually do their case plans that the social workers present. Point number 5, as reported to the legislature by the Minnesota Department of Health and Human Services in their Minnesota Out-of-Home Care and Permanency Report, during the past 5 years, over 68,000 children were in foster care. So this means that over 68,000 children were retained in foster care without the social worker ever having to substantiate the allegations of child abuse. So as reported to the U.S. Department of Health and Human Services in their ASCARS report, Minnesota has spent approximately $2.5 billion, that's $billion, over the course of the last 5 years and received $792 million in federal funding for children where the child abuse allegations were never substantiated at trial with evidence as required by law based upon Minnesota state statutes. Now I ask you this. Picture yourselves in the position of these parents. CPS has alleged abuse and taken your child without telling you your legal rights. You are innocent of the allegations. You are advised to come to an emergency protective caring hearing at court in 3 days and nothing more. You are not provided with an attorney. You cannot afford an attorney, and therefore you are ignorant of the legal process. Your child is held in an unknown location against your will, and you are desperate to get your child back. What would you do? You are forced under duress into agreeing to the allegations, agreeing to services, signing documents, and doing anything you can to get your children back. Suddenly 12 months have passed. You've complied with all of the CPS demands as I did, but CPS still petitioned the courts to terminate your parental rights as they did with me. What's even worse, statistics paint a bleak future for children who grow up in foster care. Therefore, as a society, we are failing this country's children. Minnesota spent billions of dollars on foster care instead of on the preservation of the family unit. It's time for a change in direction. These billions of dollars in funds should be allocated to preserving the family unit whenever possible instead of tearing it apart. The number one thing the organization would like is for parents to be told their legal rights in a similar manner to the Miranda rights at the time a child is removed from the family home, so they can at least be prepared for the very first hearing in court until they can obtain legal assistance of some sort. We recommend that a pamphlet is to be provided to each parent explaining their rights and what's about to happen. We would also like all parents to be provided with a website address at the time of child removals, preferably ours, familypreservation.org. We have created a short pro se document with 35 key tips and things that all parents should know regarding the legal process and their defense outcome. Furthermore, we have created a CPS video learning series that educates parents and guardians on the entire CPS process and timeline from emergency removal to trial. We welcome the opportunity for further discussions and a review of our material, or to assist in writing more material with you or the review of any new bills, anything to help the parents. I'd like to thank you for your time and allowing me to provide this public testimony. And I welcome and I'm happy to answer any questions for you at this time. Once again, thank you for allowing me to present this public testimony.